Morning. This is the final case we'll hear before a short lunch break. People versus Johnson. This is also a 15-minute mini oral argument on the application, but with lots of friends of the court briefs. So Ms. Meneses, you'll begin, and you can try and reserve some of your 15 minutes. Then we'll hear from Mr. House from the Institute of Justice, Ms. Speaker for the district judges, and Mr. Mayor for everybody else. So you may proceed, counsel.
Good morning, Chief Justice, Your Honors, may it please the court. My name is Angeles Meneses, and I, along with co-counsel Stephen Helton, represent Travis Michael Johnson. Michigan's court cost statute is unconstitutional because it causes trial court judges to have to fundraise for their very own courts by imposing court costs upon convicted individuals. This statute shifts responsibility for financing the courts to the courts themselves. And so courts have to consider their own finances when deciding whether or not to impose court costs and in what amount. This is a violation of due process. The statute is also a violation of the separation of powers because it prevents the judiciary from carrying out their constitutionally assigned function of remaining impartial and maintaining and enforcing this rule upon trial court judges. I'm open to the court's questions at any time. Your Honors, the purpose of the court cost statute is to fund the operation of the courts rather than to punish convicted defendants. And so said the Court of Appeals in People v. Kanaka. In Cameron, the Court of Appeals stated that the benefactor of successful felony prosecution is the general public, not the defendant who is paying. And so this creates a conflict of interest constitutionally between convicted individuals and trial court judges. Court costs can only be imposed after a conviction. Acquittals will contribute nothing. This creates at least the appearance of partiality in judges, which is
also... I just have to ask this question, and it's just from a very pragmatic approach. I have come to the conclusion that most people don't even understand what court costs are. Like, when they always say court costs, it just seems to be that people haven't figured out, it seems like it's very complicated to even understand what court costs even are.
It is, as evidenced by the DJC, ACLU, et cetera's amicus brief, the public does understand that they are having to pay sometimes exorbitant amounts of money and not really understanding where that money goes, where it's funneled, and why they're paying it in the first place. Here we know, according to the statute, that these costs go towards what it takes to reasonably run the courtroom. So salaries for staff, operation of the courtroom, office supplies, things of that nature. And so we know that the money is taking a complicated path through the Justice System Fund to the Court Equity Fund, and then eventually back to the courts. But it
just seems, I'm so sorry, it's just so funny because it just seems so subjective in the sense that, just from the public perspective, it's just always, well, I want to assign costs. And people never seem to know what it is.
I agree, that is troubling. And many members of the public do not know what they're paying, where it goes, and what these costs are for. But the important conflict of interest here is the fact that judges, when deciding, imposing sentence and deciding whether to impose court costs and in what amount, have to factor in this fundraising element. They have to think about the finances of the very court over which they preside. And so that creates a constitutional problem for these judges. And so it's incredibly problematic, both in terms of due process and separation of powers.
Would the judges still have that issue if there was a ceiling? So the costs, it was said, no more than $200 for any misdemeanor, no more than $400 for any felony.
That would mitigate some of the problem, Your Honor, but the problem here is also the way the money funnels. If there is a ceiling, judges still have discretion to impose up to that ceiling when they're imposing court costs, and the statutory scheme still requires fundraising for their very own courts.
So it's their involvement in the process that creates the problem.
It's their involvement in the process, it's the way the money is funneled through the various funds and then back to the courts, and here it's also the discretion that the trial court judges have in deciding whether to impose and in what amount. A ceiling would provide some additional discretion, but would not cure the entire constitutional problem here.
What if the statute prescribed a specific amount, so a floor and a ceiling, for every offense? And obviously, a judge always has not only the ability but the responsibility to waive costs because the Constitution requires it if someone can't pay. Would that satisfy due process?
That would again be less problematic, Your Honor, but still would not satisfy the constitutional violation here. Because again, it's the way these funds are funneled. So when a court's deciding whether or not to impose them at all, even if, for example, there was a mandatory amount of $600 per case, and the court can decide whether or not to impose costs at all, or to impose $600 in costs, or as Your Honor suggested, waive them if the client is indigent and can't afford them.
You changed my hypothetical. I didn't give the court an out. I said, the statute says for every misdemeanor you must, every court in the state, so we don't have this, what I agree is a obscene-looking scheme where a judge in one county imposes X amount and the judge in another county imposes 10X. We don't have that. In every misdemeanor, you must impose X dollars. You don't have the choice whether or not. If there's a conviction, you impose X dollars. Unless the fees have to be waived because somebody can't pay.
Understood, Your Honor. And yes, that would mitigate some of the problem because it would take away some of the discretion as to what amounts to impose and if you can impose or not. But the main problem with this statute is still the use of the courts to generate revenue for their very own courts by imposing these costs. And that would factor into a judge's decision, for example, if deciding whether to waive costs, as Your Honor suggested. If the client is indigent, they do have in the back of the mind this need to fundraise for their very own courts by design of the statute. And the way the money funnels through the Justice System Fund, through the Court Equity Fund, and then back to the courts themselves, and the amount the courts get back is entirely dependent on how many costs they do assess. That is the problem. And so it would cure some of the constitutional problem, but not all of it.
Would this impact, if we were to agree with your position, what about other non-penal fees that courts maybe charge in any context? How does that impact that?
That's a good question, Your Honor. It would depend on kind of where those monies are funneled through the various funds and then back to the courts. I'm not sure whether those particular penal fees would follow the same path as the court costs do here. So again, it would depend on the statutory scheme. It would depend on where that money goes. It would depend on the trial court's discretion in imposing that money. And so it would have to be handled on a case-by-case basis.
What if we changed the scheme?
We're just going to keep going.
And what if, because what I'm hearing is it's the money that when it goes through and it comes back to the courts, it's comparable to what was put in. What if it was, the formula for that was it didn't matter. It didn't matter if you had 0 convictions, and so you weren't collecting any fees or costs, but the court still got a set amount based on whatever, population or something else.
That would ameliorate some of the constitutional problem here because, like Your Honor said, when that's taken away and the amount that you get back is not dependent on the amount of costs you assess, that's a little bit more similar to what the prosecution cited in Dugan versus Ohio, where that particular mayor his salary did not depend on whether or not he assessed costs in each particular case, and it did not depend on his findings in his court.
So should I summarize by saying that there are many ways, perhaps, that maybe Justice Clement, McCormick, and Welch could write a statute that would ameliorate some of the constitutional concerns, but the point that you're presenting in this case is that we don't have those statutes, right? We have a statute that doesn't have any of those sort of bumpers or guardrails or things that might make it better. We have a statute that doesn't have that, and that is what is unconstitutional. Is that a fair summary of where we are right now?
Yes, that's correct, Your Honor. The statute, as we have it in the statutory scheme, the way that it's set up, creates that constitutional problem, both with respect to due process and violation of the separation of powers.
Can you address this sort of troubling aspect of a facial challenge? And I know one of the amici counsel will probably help us with the idea of, it's not an actual bias, it's an appearance of bias. And so this sort of facial challenge is either, satisfied or doesn't really apply. How do you address what the Court of Appeals said with respect to the facial challenge?
Your Honor, that would not be the test. And so the Court of Appeals did get it wrong when they said that there is more of a, quote, direct nexus required between the courts and the costs imposed and the money they collect. And the standard that we need to use is described in Ward versus City of Monroeville. It's the test is whether the mayor's situation is one, quote, which would offer a possible temptation to the average man as a judge to forget the burden of proof required to convict the defendant, or which might lead him to not hold the balance nice, clear, and true between the state and the accused. All you need is that appearance of partiality, that appearance of impropriety, and that's what we have here. By the very design of the statutory scheme, trial court judges are put in a very difficult position.
Why are judges required to fundraise? I don't understand that. I was a circuit judge and I was never required to fundraise. They didn't come in and say, you know, we're gonna take your desk out or you know, we're not gonna turn the lights on unless you assess big, heavy fees on everybody. In fact, the county I was in was one of the ones that didn't assess very high costs, I should say, use the correct terminology. But it's unclear to me what you mean when you say judges are required to fundraise.
Your Honor, while certain judges, such as yourself, may have not felt that pressure directly, other judges, as we've cited in our brief, there's been anecdotal letters from the District Court Judges Association, for example, sharing that they do feel that pressure, that they were told that they cannot keep their lights on, they cannot keep their doors open if they do not impose.
Isn't there a constitutional obligation for the legislature to fund the court system? So, I mean, so you're saying judges who don't know the law or don't know what their obligations are would feel pressure to say, geez, they might throw me out on the street if I don't raise a bunch of costs? Is that, I mean, that's not very solid position to take, is it?
Your Honor, I completely agree that the legislature does have the role to deal with the finances as it pertains to this, but by
And
very...
we have litigation over that by courts who think that they're not properly funded, right? And then we have to decide those cases.
Your Honor, it's the very statutory scheme that puts judges in that position in the first place. And even if particular judges don't necessarily feel that direct pressure...
Unlike the SCOTUS cases, the judge's salary is not affected, right? So there's no personal, the judge has no personal interest in collecting fees, like in the one case, right? And the judges don't appropriate the funds. They don't get to, we don't have petty cash. They never gave me petty cash, so I could decide what kind of pen. I would have loved to have been able to buy nicer pens than Macomb County would provide for me when I was a judge, but I was never given that ability. I don't think judges get to decide, make those decisions, do they?
No, Your Honor, but I'll answer that.
That takes out the other case, the other SCOTUS case. What are we left with here?
So I'll answer that question in two parts. Although courts don't have the ability, or trial court judges don't have the ability to pocket that money directly, such as in Toomey, such as in Ward, they do feel a direct financial benefit because it's allowing them to do their very jobs, to keep their staff employed, to have office supplies, to keep their doors open. And it's not that...
But we've just established that they don't need to assess costs for that reason because the legislature has an obligation to fund them. So you just mean the ones who don't understand how the system works feel that pressure?
No, Your Honor. I mean by the design of the statute itself, it creates this problem.
Does the statute say we'll increase your funding if you assess higher costs? I thought that the court equity fund depends on the number of judges and the caseload.
It does, but knowing where the money goes, knowing that it goes from the Justice System Fund to the Court Equity Fund back to the courts, and that is directly reliant on how much money a court brings in the first place.
Does the algorithms, I guess that's what I'm trying to figure out. Does the algorithm say if you assess higher costs and presumably collect those too, because a lot of courts, like my old court, wasn't particularly good at collecting. But are you saying if it says if you assess higher costs and collect a higher percentage of the fees, then you'll get more money? Is that in the algorithm? Or does it say if you have a certain high caseload and a certain number of judges, that's how we'll divvy it up? Maybe I'm not understanding how this works.
The statute also doesn't directly say that, Your Honor. It doesn't tell courts how they should impose and in what amount they should impose costs. They're merely told...
So if judges don't know the Constitution and they don't know the statute, then they might feel pressured to I mean, I think what we have here, and I agree with Justice McCormick, we've talked about this before, there are some courts that do assess costs that are hard to justify, and particularly in relation to the neighboring jurisdictions. But aren't those judges sort of bad actors or people that are doing things they shouldn't be doing? Aren't those the situations we should be addressing? Or I guess I just don't understand going from there to saying the whole system is unconstitutional based on, I'm not sure what, because it doesn't really conform to any of the SCOTUS due process cases, but shouldn't we be focusing on the few places and the few individuals who maybe are assessing costs that are unreasonably and unfairly high?
Your Honor, although this is not directly on point with Toomey, Ward, and Dugan, it is on point with Calise versus Cantrell and Kane versus White, which are two Fifth Circuit cases that cite the binding Supreme Court precedent here. Your Honors, I see my time has expired. May I briefly conclude answering the question?
Absolutely.
So even though the courts were very clear there that even though money was not directly going into judges' pockets, they still felt the benefit because they had to keep their doors open. They had to keep their courts running. And so that's what's important here. And
But I
even
think
if
that's based on the precise nature of that one county or parish in Louisiana, was it not? That actually had some language that the judicial expense fund that the money went into had a direct bearing on what they could afford. That's a little more direct, those Fifth Circuit cases, than the convoluted, circuitous route that money, I mean, you know, the money is handled in our court system, is it not? How are those cases remotely relevant to our system?
Respectfully, Your Honor, they are relevant because here, for example, in Caliste, a percentage of the commercial bond surety went into the Justice Equity Fund. And those monies that were assessed made up 20 to 25% of that fund, and the court indicated that they knew that they were reliant on those funds. The same is here. There was a trial court funding commission report created because a constitutional problem with this statute was recognized, and a commission wanted to study it and figure out how to address that problem. And even if only certain judges are saying that they directly feel that pressure and others maintain that they are not, it's the framework of the statute itself that creates that problem. And all you need is that appearance of impropriety. You do not need direct proof that someone does feel biased in assessing a certain amount or assessing costs at all. You only need that appearance of impropriety, and we do have that here, similarly to Caliste versus Cantrell and Kane versus White.
Thank you, counsel.
Thank you.
Mr. House.
Good morning, may it please the court. Joshua House representing amicus, the Institute for Justice. As the Court of Appeals opinion below explained, quote, use of the funds generated pursuant to section 769.1K to finance the operations of the sentencing judge's court, coupled with the intense pressure placed on those courts by their local funding units, could create at minimum an appearance of impropriety. And the court could have, and it should have, ended its analysis there. Everyone knows that if a judge got a $600 cut from every single conviction, that would be unconstitutional. And it is just as unconstitutional when the judge's institution, the court, is getting that $600 cut. As the Ninth Circuit recognized in the AEP case cited on page 3 of our brief, it is reasonable to assume that officials want to serve their institutions. And that's why our brief focused on what's called an institutional bias, rather than on the personal bias of the judges.
Have any courts recognized this? It seems to me there's 3 different levels of this. Does the judge, directly benefit, like you said, some portion of their salary? Do they get a cut of whatever they assess? We don't have that. Does, like the circuit cases suggest, in one of the SCOTUS cases, does the money that's collected dictate directly staffing and supplies that the judge gets to use? We don't have that either, right? So now you're onto this 3rd level of abstraction on the institutional bias. Is there any case law that's ever found that that's a due process violation, this institutional interest?
Yes, Your Honor, and just with respect, I think it's important to note the Caliste case that's already been mentioned, and this discussion is at page 10 of our brief. There's a distinction between Kane and Caliste. So the Kane case out of the Fifth Circuit discussed the judge's powers to control and administer the funds, right? So they're the ones that kind of were spending it on things, could choose to sort of spend those funds that are imposed. The Caliste case, the Fifth Circuit noted, was different. While the judge in that case did play a role in that system, what was at issue was the conflict of interest caused by the fact that judge had an institutional role to serve, and that was to be a good judge, to be a good elected judge. the cases have to get adjudicated. I mean, sure, the legislature probably had some minimum amount of funding, but the better the funding, the better the judge could do. And I think that reasoning was a large part of the Fifth Circuit saying, this is why the pressure to keep the lights on, to keep staff paid mattered, because if there's staff, as the Fifth Circuit noted, the judge can do a better role judging. And that's the interest. It's almost a professional sort of interest. It's an interest in serving that institutional role that that judge is in. So the Caliste case is right on point. And again, this institutional role is what the Supreme Court was talking about in the Ward versus Village of Monroeville case. The focus on the fact that that judge was also the mayor, that is explaining what the institutional role of that particular judge is. But the fact mattered that if the institutional role was enough to create a conflict of interest. And I'll point this court to another case, cited page 8 of our brief. It's the Harjo versus the City of Albuquerque case. And I think the reason that case is so important is that the Court of Appeals analysis here said that, well, this whole policy isn't the judge's fault. They didn't create the policy. They don't spend the money. There's no nexus was the term that was used by the Court of Appeals. But if you look at that case, what's interesting, the District of New Mexico said, look, the prosecutors had a financial interest in more forfeiture prosecutions because that money returned to their office. But they didn't set that policy. In fact, it specifically says in that case it was the City of Albuquerque, not the prosecutor's office, that created that policy. And yet because the prosecutors benefited from that, they had a financial interest in every single prosecution that they brought because they knew that the proceeds of those prosecutions would return to their office. And I think that's what makes the judges here, trial judges in Michigan, that puts them on par with those prosecutors in Harjo, where they have.
I point out that the funds going to that office to be spent, perhaps by that prosecutor, in whatever manner they wish, is a lot different than what happens with our judges who don't have a checkbook and they don't have a petty cash, cigar box in their drawer, and get to spend the money however they want. So again, I think you're omitting to mention that the money here travels a very circuitous route and is not appropriated or with the involvement of the judges who assess the costs.
Well, and I think this is what's important and why the appearance of bias standard is so important here, because this money is traveling back to the courts, and for a defendant that appears in these trial judges' courts, they know that their conviction, maybe it's not the judge who gets to decide whether a dollar goes left or right in terms of the actual spending, but the defendant knows that the court, in order to keep being a court, in order to keep running, has to convict him. And that's a conflict of interest. A defendant should enter the court thinking the court is neutral. And if you look at the Trial Court Funding Commission report, on average, 26% of trial courts
So what does that lead to? I'm not sure where all this ends, but the people who get acquitted should have to pay the same cost as people who get convicted for using the court services?
Well, I think what it leads to is that if the court is a public service, it's funded by the public. It's not funded by convicting defendants. That's the idea that if a defendant has to be convicted for the state government.
Your bottom line is no cost could ever be assessed, consistent with the Constitution.
The Supreme Court allows for some costs that are de minimis, but nobody here is arguing that a quarter of these trial courts' budgets are de minimis. No one's arguing that $300 million statewide every year is a de minimis amount. No one is seriously making that argument. And so, sure, court costs might exist to some extent, maybe to defray some very minor costs, but I mean, even the small $50 fee in Ward versus Village of Monroeville was struck down as unconstitutional. And if there are no further questions, we'd ask this court to reverse. Thank you.
Thank you.
Good afternoon. Excuse me. Good afternoon, Lisa Speaker for Amicus Curiae, the Michigan District Judges Association. Our position is that 769.1K1B3 is unconstitutional and should be stricken down. It presents a corrupting influence on our justice system, and there's at least 3 possible ways that it violates due process, specifically with respect to the judges who are sitting on these cases and having to decide whether to convict or acquit, and then after conviction, how to sentence them
Ms.
with
Speaker,
fines
let
and
me
costs.
get to my concern with your position. Michigan can take great pride in Frank Murphy, right? He was a former recorder's judge in Detroit, a former mayor of the city of Detroit, former governor, and a former justice of the United States Supreme Court. And Justice Murphy wrote in the case of Craig v. Harney, a First Amendment case involving a contempt claim where a trial judge didn't like being criticized by the local paper. Judge Murphy wrote, "Judges are supposed to be people of fortitude, able to thrive in a hardy climate." And it seems to me Justice Murphy's observations apply equally here. My concern is, how does your position square with the rule that trial judges are presumed to be people of fortitude, able to thrive in a hardy climate, and they're presumed to be impartial, and that the party asserting partiality bears a heavy burden to overcome this presumption? I really don't see how your position nullifies or overcome these presumptions.
So I think the United States Supreme Court said it in both Toomey versus Ohio and in the Ward versus Monroe case, where, and I'm going to quote, "The requirement of due process of law in a judicial procedure is not satisfied by the argument that men of the highest honor and the greatest self-sacrifice could carry in it note without danger of injustice. Every procedure that provides a temptation to the average man as a judge to forget the burden of proof required to convict, which might lead him not to hold the balance, nice, clear, and true, between the state and the accused, denies the defendant due process of law." And so to further address your comment, Justice Sara, and possibly also commenting on Justice Viviano's comments earlier, it's not that, at least from my association, the Michigan District Judges Association, it's not that they don't, one, understand the Constitution, because they do, and it's not because they don't understand the funding system, because they also understand the funding system. In the context of the district court judges, there has been significant pressure to bear on them, and even though they don't put the money in their pocket, because their salaries are not paid by the county or not paid by the court funds, everything around them, the existence of their court system, is funded in part from the imposition of cost. And as the affidavits and letters that we supplied with our amicus brief point out.
So if the mayor holds out the prospect of a new courtroom, that's enough for the judge to I can't remember all the lofty rhetoric, but not be fair and true?
I didn't hear the first part of your question, Your Honor.
If the mayor promises the judge or suggests that there might be a new court building, maybe the court facility's 100 years old. This happens in some jurisdictions, right? And so they want the funding unit provides the housing for the court, right? I mean, isn't this what this is all about? And so some places they want better facilities, and so then there's a suggestion that they should raise costs or impose costs to raise money for this, or try to set up some type of separate fund.
That would exactly present the constitutional conflict that we're talking about if, for example, the mayor were to say, hey, if you can impose more cost on your convicted defendants, you might be able to get yourself a new court building.
Is that legal under our funding scheme for courts to set aside costs for that purpose?
Is it what?
Legal?
So the judges aren't in charge of how the funds are distributed to them. The problem with the district courts, and I appreciate your comment about how you did not witness this or experience this when you sat as a circuit court judge.
I'm not saying that some people don't charge costs that are unreasonably high. I was a lawyer once too, and I went from court to court and couldn't figure it out myself. But that's not the point here. I mean, the question is whether this whole scheme is unconstitutional. That's a pretty weighty question, and there's not a lot. Frankly, I don't see a lot of precedent supporting the notion that it is. So, but I do think we have to sort of drill down and see what's really going on here. And it is a bit striking to have the district judges come in and say, we can't be fair.
Well, and the reason
I mean, is that in fact what they're saying? Just to pony off of that, is the District Judges Association admitting that some of their members have failed to be impartial in this setting?
I don't think that we have said that in that way. I think what we are saying is that the fact that they're being asked to impose cost is an insidious influence. So even the most ethical judge who doesn't realize that they're taking that into account might be doing it without realizing it. And that goes to a couple of the letters and affidavits that we supplied where the judges were told directly that, hey, if you don't bring in enough revenues, you're going to have to adjust your budget to account for the fact that your revenues are down. And I'm not saying that those judges took up the county on that imposition.
The problem with this is there are always certain budgetary realities, right? So if the ticket revenue goes down, you know, something has to happen. We might not need as many clerks handling civil infractions, right? If the officers aren't writing the tickets, we might not need as many police officers. There's always going to be adjustments based on revenue that probably have something to do with volume. We can't take that consideration out, right? We're not going to just appropriate funds without considering caseload and, you know, all these different factors.
So there's a
right?
difference, Your Honor, in the fact that, let's just say hypothetically, the police officers aren't issuing enough traffic tickets. And if we tell the police officers to go.
By the way, I don't know what enough is or what the correct amount
Right,
is.
no, I understand
The
that.
only point is if they were doing 100 and then the next year they did 10, that we're in a
Right,
different situation.
and the budget might be decreased on the police officer side because there's not, the revenue's coming into the courthouse. But the difference is when the judge, you know, who is an attorney who's sworn to uphold the Constitution, is being told that if you don't bring more funds into your courthouse, we could evict you, or we're gonna have to.
Well, they can't evict you. So, I mean, any judge that doesn't know that shouldn't be a judge, right? They can't evict you. They can't make you hold court on the sidewalk. They can't do that.
With the district court, funding is different than the circuit court, and I'm not an expert on how the funding system works, but in pages 18 and 19 of the amicus brief, we talked about the 3 different classifications of the district courts and the funding.
Some are by the county, some are by the local
And my understanding is
municipality.
that the way the funding works, and the way that it's different from funding for circuit court, is really what's putting the pressure to bear on the district court judges.
My speculation would be slightly different, which is that the district courts are generally smaller in size, and so they're more focused on the changes to the budget than maybe some of the larger courts. And they're, you know, but there's different considerations. But am I wrong? Can the city say, we're gonna evict you? Is that a serious charge that a judge says, oh my gosh, I won't have a place to go to work? And that's what we're talking about here? They don't know that they could sue, and that the court's gonna then say, no, you have to have adequate funding, which probably includes a roof over your head, for at least as long as we think judges should have courtrooms?
Well, and the question, Your Honor, is where does that adequate funding come from? Does it need to come on the back of convicted defendants, which it does through the subsection B3, or does it come, as fellow Amici said,
Well, regardless
through
of
the
where it
public
comes
system?
from, the local funding unit has the obligation to write a check to cover the housing of the court, right? That's not gonna be a question in that lawsuit, I don't think. Where did
So-
the money come from?
And it's interesting that you say that because we've been having the same conversation since at least 2014, when the legislature enacted B3, when the judges went and testified before the legislature opposing the addition of B3 because it put them in an untenable constitutional position. So it's a problem that has been, well, it existed a long time because in 2014, the legislature said that they had been trying to fix the issue for 10 years. And here we are in 2022, and all the legislature is doing is extending the time for them to do something. And they've extended it now 3 times, and so here we are, the statute doesn't expire until October 2022. And it seems to me, after we had this conversation when we were here for People v. Cameron in 2018, is that the legislature is not really gonna do anything until this court says something needs to change. And to address your comments, Justice Viviano, I know I'm out of time, but I just want to remind the court that in 769.1 K, there's like 7 other ways that defendants are assessed with cost and fines. This is just one of the ways, and this is the one that's the most amorphous, the one that is about funding the court system in a generic sense, that's not tied to that particular defendant, what that particular defendant caused the court to incur expenses, such as one of the elements is the assistance of counsel to the defendant. One of them is the emergency services that were required because of the defendant's conduct. And so this is the one category that is just so broad and amorphous, and it's really just meant to fund the court system, which shouldn't be held on the backs of the convicted defendants because it is a public obligation to fund our court systems. Thank you, Your Honors.
Thank you, counsel.
Chief Justice McCormick, and may it please the court. Phil Mayer, appearing on behalf of amici ACLU of Michigan, Detroit Justice Center, Street Democracy, the Michigan State Planning Body, and the Legal Services Association of Michigan. You've already heard from several of my learned friends as to why subsection B3 violates the Due Process Clause. So with my few minutes, I'd like to focus on the second issue, which is separation of powers under the Michigan Constitution. There's no dispute that subsection B3 was designed to fund courts and actually has that effect by requiring courts to function as tax collectors on convicted defendants. And there are overwhelming reasons to believe that the statute at least results in pressure on judges to fund their own budgets through more convictions and assessments. Indeed, even the people of the state of Michigan concede in their brief that they, quote, do not dispute the possibility that some judges feel a pressure to obtain convictions under subsection B3. So the only question is whether this statute is constitutional, and subsection B3 violates separation of powers principles under the Michigan Constitution for two separate, albeit related reasons. First, it foists the quintessentially legislative power to tax onto the judiciary, turning every trial court in this state into a tax assessor and a tax collector. Second, subsection B3 threatens the independence and integrity of the judiciary by making court budgets dependent in part upon convictions and cost assessments. This not only actually does distort judicial decision-making in some cases that are documented, it also creates a widespread public impression that such distortions are common. I welcome the court's questions at any time. With respect,
I have a little difficulty with the notion that this incentivizes judges to convict, so that, I mean, I just want to run this through my brain. The judge is there and they're thinking, well, this is a close case, but if I convict, then we can get some costs. That's a thought that the judges in their affidavit said runs through their head. Like, this person might be innocent, but if we convict, we can get costs. I mean, isn't that, it seems to me, you know, a high percentage of cases result in convictions anyways. Are the judges really dependent on the cases of the court system funding, dependent on the cases at the margins? Is it really I'm just trying to understand this, because I did see some of this in the papers, that this increases the number of convictions in some significant way from people who wouldn't be convicted otherwise?
well, it's not just about the convictions, it's also about the costs raised as a result of a conviction. And the statute permits those costs to be assessed, so it also provides an incentive for everybody who is convicted to assess maximal costs.
Yeah, no, I get that. I'm just trying to make sure I'm just trying to nail down. You said you made the representation that you thought it put pressure on judges to increase convictions. The inference there, or the only way to think of that, is that the judge was not going to convict the person otherwise, but they're convicting them so that they can assess $200 in costs and add it to their fund. Is that really what you think is going on?
What's important is whether there is pressure, not whether or not any particular judge is succumbing to that pressure. But from the separation of powers perspective, I'd like to point out that our anti-foisting argument that the taxing power cannot be foisted onto the judiciary by the legislature doesn't actually depend on the incentives it creates for judges. The anti-foisting principle is about separation of powers and about the fact that the taxation power, this isn't a formalistic point, the taxation power involves the balance between the need of government to be funded and the fact that, as we all know, taxes are quite unpopular. That's why the taxing power is vested in the legislature, and this court has referred to the taxing power as the supreme legislative prerogative. And what we're dealing with here in this statute is a case where the legislature has tried to take their supreme legislative prerogative, which this court says they cannot abandon, and stick it onto courts. And when it does so, there are two important effects. One is that the court is dragged down into the political mud in the public's mind as a tax raiser and a tax collector. Second is that poisons the relationship between local governments, between the funding units and their courts. You asked several questions of my friends, Justice Viviano.
Before you move on to all those interesting questions I asked before, let me just ask you about the anti-foisting argument. It seems to me the legislature's made a judgment that they think that people who are convicted, as opposed to people who are acquitted, should bear at least some of the costs of the court system. And if that's true, your anti-foisting argument suggests, I think, that, at least that you think, that judges are not in the best position to assess those costs, that it would be better assessed somewhere else. So who else would be better to assess those costs on the class of people, if it's true that the legislature is focusing on defendants who are convicted? Who would be better situated, what agency of government, than the courts to do that?
Justice Vivian, I wouldn't presume to tell the legislature how to fund precisely because it is their supreme prerogative to decide how to fund, except to say that what they cannot do is violate the Constitution by making that the judiciary's responsibility to bear the public opprobrium of taxation and to bear the need to negotiate with their funding units in the ways that are documented. Whether or not any judge has ever succumbed to that pressure, I think the record is very clear that funding units put pressure on their judges. The funding units wouldn't be in a position to put that pressure onto the judiciary were it not for the legislature unconstitutionally foisting on the judiciary responsibility for funding government by raising revenue in the first instance.
You're out of time, but if you promise to be brief, I'll ask you to respond briefly to my other questions since I took up all your time.
With the court's leave, I'd be happy to.
Sure. Please.
Oh, I'm sorry.
If you promise to be
You were going to
brief.
say before, you asked a bunch of questions to my friends, and you were about to answer, he cut
Yes.
you off.
And took up all the rest of your
He interrupted you
time.
with a nice new question.
I appreciate
He's
that.
giving you an opportunity.
I believe I addressed it with the end of my last question, which is that you asked several
You
questions.
rebutted everything I said with that last. Unbelievable.
I hope I didn't rebut, but answered.
All right, thank you, counsel.
Thank you
Thank
very
you.
much. Yep.
Good afternoon, Your Honors, and may it please the Court, Assistant Solicitor General Linus Banghart-Lynn, on behalf of the people of the state of Michigan and the Alpena County Prosecuting Attorney, respectfully requesting that this Court deny leave to appeal or affirm the decision below, because subsection 1B3 does not violate due process, the due process rights of a defendant to a neutral judge. I think that my new friends have made some very good points about how it is difficult to decide how to fund courts, and I don't think there's any dispute there. I think that most of the arguments made are really arguments about sort of what's the best way, what's a good way to fund them, and those are not the arguments that are before this court. This is, the decision to be made here is really squarely in the hands of the legislature within the boundaries of due process, and so we would focus on the due process question here of whether the defendants can get a fair trial, can get a fair judge with this subsection intact. And as you know from our briefing, we rely heavily on Dugan, and we contend that that controls this issue because just like here, in Dugan, the judge's salary, the mayor's salary in that case, the judicial officer's salary did not depend on whether or not he convicted in any given case. That's the same thing is true here. The costs collected in those cases in Dugan went into a fund, and the judge's salary was paid in part out of that fund. Other things went into that fund. That's the same as here. And nobody has really distinguished Dugan here. Nobody has really explained why that's different. The defendant hasn't cited it. I think only the, one of the amici has really attempted to distinguish it. I think it was the sort of what I'll refer to as the, no, it's the Institute for Justice amicus, as saying that, oh, I'm sorry.
No, go ahead.
Oh, I thought I heard a question. You know, that the judge in Dugan, quote, didn't have a reason to care for his institution's finances. And that's not a distinction. Of course, the judge, the mayor of Xenia had a reason to care about the finances of the city of Xenia, right? But that was true in Dugan, right? It was not, the reason Dugan was decided as it was is because, not because there was no institutional interest in collecting funds, it's because there was an institutional interest, but it was not direct and it was not personal, it was attenuated, similar to our system of funding courts here. And so really with no distinction, I think that controls the federal question. I will, I think, turn to, and of course, obviously I'm here for questions at any point, but I'll turn first to sort of the points made in the reply brief. The sort of argument one in the reply brief kind
Counsel,
of talks,
would you
please.
kind of make the argument that like this is analogous to police departments or, you know, other entities that assess fines as a way to create revenue? Is it analogous, similar, different?
No, it's different, and I think that the case law is clear that when it is the executive, when it's law enforcement or a prosecution unit that does that, there are different considerations at stake, and you know, I haven't kind of fleshed out sort of the details of that because this is really about the judiciary, but it is a different analysis when it's a process, because we don't expect the police and the prosecutors to be neutral in the same way, especially the prosecutors. in the same way that we expect the judges to be neutral. I mean, we expect everyone to be fair, but neutrality is really specific to the judiciary.
So could one, oh, I'm sorry, please. Oh, I was just gonna say, cause I'm just trying to figure this all out. I mean, then ultimately, could one then put forth the argument that maybe if you're looking at this from a purist perspective, because of that issue of neutrality that, we're talking about, that maybe it's, if there's even an appearance or a concern, that it's best to focus on being neutral, which would be to eliminate this process?
Well, I think I can take that question in two different ways. I think one way to take that question you asked is it best to focus on that? Mm-hmm. And I would say that I don't have an opinion on that because that's a question for the legislature. Now, if the question is, does it violate due process, then the answer is no, because the test is not whether there is any pressure, right? This is what the standard that's set forth in the defendant's reply brief. If there's any pressure on a judge to convict, that violates due process. If that were true, Dugan was wrongly decided. But it wasn't. And because judges face many pressures to convict and many pressures to do the various things they do. They face the pressure of re-election. They face, they need to fundraise. They need their parties nominate, perhaps, depending on what judge it is. And yet we trust the judges to do the right thing in the face of those pressures. And we know that they do. And we know that sometimes judges make unpopular decisions in the face of those pressures. And there's no evidence. I am sympathetic with the District Judges Association brief in terms of the pressures that they face, and I think that we should be grateful to those judges that they don't pass along those pressures to the criminal defendants before them. They don't go to work every day and violate the due process rights of every defendant that comes before them, as defendant has accused them of doing. They don't do that, right? They do their job, and they do their job fairly because we don't have a system like Toomey, where a certain cut, and there's no de minimis exception. If $1 of this $1,200 went in Chief Judge Mack's pocket, I wouldn't make a de minimis argument here. I'd say, of course, kick that, of course, right? Not $1 does, right? Or into a fund that Chief Judge Mack administers,
So,
right?
I guess what I'm struggling with, and I just try to keep things simple, but what I'm really trying to struggle with on this is that, is this a fee or is it a punishment?
It is a tax.
I mean, I know we've discussed this at length,
Yes.
but how do you see it?
I see it as a tax, for better or for worse, and I understand, I've read Judge Shapiro's dissent, and I understand that the argument is made that that he says it's not a tax or that it's an unconstitutional tax. I think that's an argument for a different day. I think Cameron decided that it is a constitutional tax, and this court unanimously denied leave in Cameron. So I think the question about whether it's a tax and whether it's an unconstitutional tax in terms of as a tax is not before this court, right? The question is, does this tax create such a pressure on judges that they deny the due process rights of the defendants before them? So yeah, I would agree that it is a tax. I think that the precedent is clear on that, and it does indeed fund the courts. And I think that the arguments, I won't say that I agree or disagree, but I will say the arguments are well taken as to whether that is the best way to fund courts. But I think there was language, if I remember right, it was in the Ninth Circuit case, the Alpha Epsilon Phi case, where the court referred to a system as sort of being maybe less than optimal with respect to due process, and yet still upheld the system because it was not violative of due process. There's a difference.
Would you say that the fees correlate to the actual costs?
The court costs that are assessed under...
Yeah, would you say if in many situations that they actually create equilibrium?
I think that the statute requires them to be, and if...
But do you think in practice that they do?
I don't think that we have a record on that, and I think that that is something that would need to be developed. I think that if a defendant were to make that argument, then say this statute... There's a difference between saying the statute is being violated, right? That's what if the costs were being assessed out of proportion of the operating costs of the court, out of proportion of what the statute requires, which was meant to be a Cunningham fix, right, then that's an argument that the statute's being violated, and that's a different challenge. Here, the argument is that even if the statute works exactly as intended, it violates due process. That's the argument that the defendants have brought, that the defendant has brought.
Counsel, can I talk about the frame that we're supposed to be thinking about the due process question? We've spent a lot of time talking about the actual pressure judges feel, and I think you've conceded that in fact, and you can't not concede it because the judges have said, a number of them, that depending on their funding unit, they get direct pressure. And I agree, I actually trust every one of them to stand up to that pressure, so I'm not worried about that. But isn't the problem the one the Institute for Justice raises, which is the appearance to, if you describe this scheme, even the indirectness of it to people on the street, who maybe are not lawyers who grew up in it, and we have a little bit of problem blindness to what we're dealing with, don't you think to a person they would say, wait, what? A portion of the fines and fees, a portion of the costs imposed on convicted individuals funds the lights and the staff of the court? Like, wouldn't that appearance be across the board a problem?
No, I don't. I actually don't think so. And I hope you don't feel I'm being disingenuous. No, I think that there are many people who would say it is perfectly appropriate that the people, not the people accused of crime, right? The people convicted of crime, found guilty beyond a reasonable doubt, or admitting their guilt or refusing to contest their guilt,
I'm not saying they shouldn't pay. I'm not saying that. I think maybe I didn't give you too great. If you said to a person on the street, the judge makes the determination of the amount of cost to assess, and by the way, it can be radically different from judge to judge and from county to county, depending on even though it's the same offense, and some portion of that amount that the judge determines goes back to fund the things that support the judge's courtroom. Don't you think most people, not lawyers, who maybe grew up with some problem blindness, would say, like, wait a minute?
I think
that doesn't sound right.
I think if you told them, the way you phrased that, and I don't think this was intentional, but the way you phrased that suggested to me that the funding the courts received is somehow proportionate to the costs they generate. And if that were true, I think we might have a Caliste problem. And I don't think that's true, right? The costs that go into the entire fund, but as Justice Viviano pointed out, the algorithm is based on the case load and the number of judges.
No, I know how it actually works. I'm just asking about the I want to change the frame from actual bias to appearance of bias and conflict.
I really don't think the average. I don't think we should decide due process questions on public opinion polls. But I think that. But that's not what you're saying. I don't think the average person would be that offended to say, no, we do offset some of the costs of operating courts based on. They're called court costs. I think the name court costs, and I think Justice Bernstein's questions are well taken as far as I think not everyone really understands in detail exactly how they work, but the fact that they are called court costs, I think signals to people that this is meant to offset the operation of the court. In fact, I think that if you were to tell some people that money actually goes right back into that court's budget, I think that a lot of people would not really be surprised or offended. Now that, again, would be a due process violation, even though it wouldn't offend some people. But I think they would say, yeah, court costs, that makes sense. It costs money for the court to operate. They assess court costs, and it offsets those costs.
But does that suppose that it's, maybe again, we're talking about this hypothetical person on the street. Maybe the idea that court users, right? You use this public service, so whether that means I have to pay, $375 to file an app for leave in our court, or I have to pay a $20 motion fee, or I have to do that, okay, like that might be, but the class of people that we're talking about that are funding it are not all users, they're convicted defendants, criminal defendants, right?
Right, exactly. Well, and I think that raises a policy question. I think you can say, and I think reasonable people can differ on that, and that's why it should be entrusted to the legislature. I think some reasonable people could say these are sort of the least popular and poorest and most disadvantaged people, and it doesn't make sense to fund the courts on their backs. And I think other people might say the reason the courts are so busy is because people are out here committing crimes, and if you're going to choose to commit a crime, and then you require the state to sort of go through this process to bring you to justice for the crime you decided to commit, then in that case, it's reasonable to expect that you're going to help fund that court that exists to bring you to justice. I think that some people might sort of vehemently disagree with what I just said. Some people might stand up and salute to what I just said.
But you're leaving out an important factor, which is the judge gets to decide the amount of the cost to assess, right? I think I might agree with you if it was the legislature passed a long list of here's what will be collected for this offense, and here's what will be collected for that offense. But no, we leave it to you judges to determine how much to impose on this person versus that person. And in the very next county, it can differ by significant amounts of money.
Sure.
I mean, how does that appear fair?
Yeah, I think that the variance between counties, I mean, certainly can appear problematic, and it may be problematic. It may be that different courts have different expenses, and because you're supposed to assess costs based on your actual expenses, some variance. But the variance is very wide, as the defendant pointed out in the materials in the appendix. But does that variance flow from a judge being biased against a defendant because of B3? And it doesn't, right? And there's no, again, the defendant never connects the dots between how the variation from county to county indicates that some judge isn't being fair. It could be that some judges don't understand, and I mean fair to the defendant. Some judges don't maybe understand how to assess the costs correctly, and those can be dealt with on a case-by-case basis.
I believe all the judges are fair. I'm worried about the appearance
of
unfairness.
Sure. I don't think that it raises the appearance of bias in a particular case in terms of did the defendant have a judge that was unfair. If the system itself sort of looks bad because when the aggregate data is collected, we see a spreadsheet with different things, that doesn't tell us anything about whether Chief Judge Mack had a bias or an appearance of bias when he accepted Mr. Johnson's no contest plea. I think it's too far attenuated. And it is a question really for the legislature or for scale. I mean, again, these are all reported. These numbers are reported, and I think that if a problem exists that, sorry, may I just?
Oh, please.
Thank you.
Absolutely.
I think that the court can look at that and say, what is this? What's going on between this county and that county? What happened in Wexford County in 2017, right? But it wasn't that in Wexford County in 2017, some judge decided, I have to be unfair because we need all this extra money. That's not the case, and we didn't see an increase in court costs, for example, in 2020, a significant increase, as the defendants said in their brief. The average costs remained basically level. So.
Counsel, I have a question. I do realize that time's expired, but if you were not to prevail today, what would I always like to understand things from a pragmatic perspective. What would happen?
That's a good question. The defendant has asked for his money back. He's raised an argument that that his judge was not fair, that his judge was not neutral. That's a structural error that infects the entire proceeding. Even a defendant who pleads no contest has a right to a fair judge. So it is difficult for me to square the relief requested, and the Alexander panel, the unpublished Court of Appeals case that preceded this one, pointed out that sort of discrepancy, that oddness between the relief they're seeking and the violation they're alleging.
But what would happen? Would this open up, I mean, could this create, as you said, it's structural, could this create issues that are unforeseen to this court?
I think that it might. I think that, it would allow...
And give some examples if you could.
I mean, any defendant who has been convicted, any defendant going forward, I think you could just say, well, the judges are now operating without this ability under B3, and so they can be fair. But for any defendant who's already been convicted, they now have an argument that their judge was biased or had an appearance of bias, that their judge violated their due process right to a neutral judge. And that, even though this defendant has not asked for that, that would require vacating the conviction because every defendant has a just fundamental, it's possibly the most fundamental due process right is to a neutral judge. And so I think that I agree with the Alexander panel that I don't understand asking for the $1,200 back at the same time you're arguing, my conviction was unconstitutional, please let it stand. I think that's something that can be addressed on rebuttal, I suppose.
Thank you, Counsel.
Thank you.
Madam Chief, do you mind if we ask the opposing, I know everyone's out of time, but I'd like to hear if someone could respond. I just want to hear what their argument back to that, because that's a pretty significant...
I'm sorry, I didn't mean to suggest rebuttal when there was no rebuttal time left.
No, but I just want to hear, because I think...
He has a question for Ms.
Yeah,
Menzies.
That's kind of a pretty dramatic note to end, so I'm just curious if the other side has a response.
If there are no other questions from the court, I thank you, and we request deny leave or affirm the decision below.
Thank you very much for your argument.
Thank you.
Justice Bernstein has a question for you.
Basically, that's a pretty significant consequence that other counsel made. I'd just like to hear if you have a response to that.
Yes, so the remedy that we're not asking for plea withdrawal here. We're not saying that in particular Judge Mack was unable to be impartial in Mr. Johnson's case, and so his conviction should be vacated or his plea withdrawn. The constitutional issue here occurs at the time of sentencing, when by virtue of this statutory scheme, the judge has discretion to impose costs or not, to impose them in a certain amount, and in doing so has in the back of their mind, because again of the frame of the statute, that they have to fundraise for their courts. And
But go to what he had indicated, which was that this is going to create an
Every
issue.
single criminal defendant's going to be able to come in and
If you,
get
that's
their
what
costs
I mean.
Is
I'm
the sky
really,
gonna fall?
Right, I'm trying to understand. I mean, I'm really trying to figure out how to approach this case and what to do. It's a very challenging issue, and that's a pretty significant implication. I just would like you to address that.
that may be the case, that if the statute is declared unconstitutional, that if this court were to find that it's retroactive, that other defendants that have been assessed court costs under that statute may seek compensation for court costs that they have paid. That would respectfully be up to the legislature to address. It's this court's decision whether or not the statute is constitutional and whether or not to apply that decision retroactively or not. And so that very well may be the case. But there are bills that are currently being proposed showing that the legislature does already have at least the possibility that the statute may be declared unconstitutional by this court in mind. There was a bill proposed that the remainder of the funding be made up by the state court, by the states, as opposed to the trial court. And so those are the remedy for that, and how that will be addressed by the legislature should this court decide that it is unconstitutional, which only this court can do.
Thank you, counsel.
Thank you all. The case will be submitted. We will be back at 1:15 for one more case.